Another aspect to be considered is that Honorable the Supreme Court, in the case of Satyavati under bracket Supra, deprecated unreasonable delays in execution of decrees rendered by courts of competent jurisdiction in the following manner: para code. This code, again in the case of Marshall Sons and Company under bracket First Limited versus Shahi Orators under bracket Private Limited and another under bracket 1999 to SCC 325 was constrained to observe in para 4 of the said judgment that para code. It appears to us, prima facie, that a decree in favor of the appellant is not being executed for some reason or the other, we do not think it proper at this stage to direct the respondent to deliver the possession to the appellant, since the suit filed by the respondent is still pending stop. It is true that proceedings are dragged for a long time on one count or the other and on occasion, become highly technical, accompanied by unending prolixity at every stage, providing a legal trap to the unwary staff. Because of the delay, unscrupulous parties to the proceedings take undue advantage, and person who is in wrongful possession draws delight in delay in disposal of the cases by taking undue advantage of procedural complications. It is also a known fact that after obtaining a decree for possession of immovable property, its execution takes long time, decode para. As stated by us here in above, the position has not been improved till today. We strongly feel that there should not be unreasonable delay in execution of a decree, because if the decree holder is unable to enjoy the fruits of his success by getting the decree executed, the entire effort of successful litigant would be in vain. Decode para. It is also relevant to indicate that any person having an interest in the sued property with regard to which a decree has been passed has a remedy not only under section 47 but also under rule 21st rules 97 to 104 of the code, due to which also the provisions of order 21st, rule 29 of the code are required to be used only in exceptional circumstances. Para. With regard to reliance placed upon UP Judicial Services Rules, 2001 is concerned, it is quite evident that the same pertains to service regulation of judicial officers, which would be administrative in nature and by no stretch of imagination can be deemed to include judicial proceedings as has been submitted. Para. So far as the judgments relied upon by learned counsel for the petitioner are concerned, reading of the same makes it evident that the same have been passed only on the ground that the trial court had passed orders impugned therein without considering the provisions of order 21st, rule 29 of the code, and therefore, the petition had been allowing remanding the cases for fresh consideration in terms of the said provision. A reading of the aforesaid judgments makes it evident that no proposition of law nor any ratio decidendi is evident in the aforesaid judgments, and as such in the considered opinion of this court would not have any binding nature.